administrators and policymakers are always going to have some level of tension between them, and that's our role to try and work those things out. I don't see myself as catering as much as it is to say, how do we make the policies work that have been in place in practice, recognizing the changes.
One final comment, and thank you very much, co-chairs, for allowing me the latitude to ask one final question. Maybe there's a silver lining in this cloud, and I see that silver lining is this. By your actions that you presented to us, it should result in that we don't have to decide on GAB being engaged in emergency rulemaking, because when calmer heads prevail and when logic really presents itself in this argument, we're going to see that it's extremely important that GAB remain independent of political influence to the greatest extent possible. And when we have a body such as JCRER made up of a majority of the majority party, that pressure can result in unfair or unreasonable results. And the fact that we will not be making any, or asking you to do any emergency rules as a result of your action today, there's one small glimmer of hope in what this body is doing. Thank you.
I would just comment that Wisconsin's fortunate to have an independent entity running elections, campaign finance, and ethics when you compare it to other states. My position in many other states is a political appointee. It's either an elected or appointed Secretary of State or the Lieutenant Governor in 40 of those states. And so we're in a good position as far as that goes, but I think there's a recognition, as I said before, that there's still going to be a give and take between those who set the policy and those who administer it. And that's the part that I see this process.
Thank you.
I would just say in response to our Representative Hebel's several comments about what's going on here today, I would remind him and the rest of the committee and everyone in the room that what's going on here today is the Joint Committee for the Review of Administrative Rules is having a hearing which was scheduled as an executive session, but we are holding back on that facet of our hearing this morning. But what we're doing is clearly within the bounds of our responsibility to express legislative oversight of state agencies. And just because certain committee members don't agree with what the majority on the committee would like to do, it doesn't mean that's partisan, but if you agree with us, it's nonpartisan. We're well within our responsibilities, and we, quite frankly, would not be carrying out our responsibilities if we didn't express our oversight of state agencies. Next, we have Senator Taylor.
Thank you, Mr. Co-Chair. The first thing I want to say is I understand Representative Hebel's concerns, and I understand why. We've had a climate in this building, and experiences including, for example, seeing the ropes is a reflection of where we are that is different than where we've been, as well as in the difference between what the chair said in the last meeting was even a reflection of why there was concern in that meeting. Mr. Chair, you said that it was going to rulemaking, where Madam Chair said that we were considering what was going on. So there is a reason. Representative Hebel is not just going off on some tangent that has no substantiation. However, I need to deviate from the level of concern that Representative Hebel has for these reasons. First, I want to commend the Executive Director, Mr. Kennedy. I want to commend you because I've often learned in this building that if people from all sides talk about you, you might actually be getting it right. Sometimes is what they say if everybody's not happy. I've heard that you're partisan on the side of Republicans. I've heard you're partisan on the side of Democrats. I heard many of those different things. What I see today, although I understand the concerns that Representative Hebel has articulated, is I see that you heard the concerns that exist in the committee in the same way that I want to believe that the majority heard the concerns that were articulated by the minority party in the last meeting. And although there may have been by some an intention to go in one direction, or they were leaning, let's say, towards one direction, that there was an influence in what they heard to do something different. And I want to believe that you tried to figure out how we could get to somewhere and still honor what the board, your board recommended, but try to take into consideration the things that you heard and that you received. And I think that that's important. I don't want to discourage that by the minority, by the majority, or for that matter, by anybody who comes before a legislative committee and hears the issues that are put before us. Now, I want to make sure, since I came in, now the one thing I will tell you I don't like is I got the memo today when I came and sat down. Now, that was worse than the 24-hour, 14-minute notice. I would have liked to have this before I came so that I could have read over it, understood it thoroughly, and so, you know, that's a piece that I need to articulate that I did not appreciate. But if I understand appropriately, of the 4 items that you were recommending, there were items that I argued made access easier and items I argued that made access more difficult. If I understand correctly, on the pre-populating the form issue, the form will be able to be pre-populated by your recommendations, but not necessarily with the name and the address of the person, but with all other pieces?
Voter-specific information will not be included. As I indicated to Representative Hill, I think we're drawing a very tight legal line on this process. I think it responds to the legislative concern about what it means to be engaged in the petitioning process. And I think that was a reasonable point. And, you know, looking at this, discussing this with the staff, and then, you know, I think we could articulate that there's a way to draw that distinction while still recognizing practices that have been in place for years when it comes to information that applies to all voters, such as the municipality they live in, but here they sign the petition. And one of the bases for these rules was the fact that the very first recall petition was thrown out because there was not the year of signing on that. The Supreme Court upheld that decision. As a result, we have a very tighter rule on the year of signing.
One question then in regards to the pre-populating issue. We spoke about the similarities, the pre-populating issue, if I'm not mistaken, with absentee ballots.
That's correct.
Can you please tell me if in absentee ballots pre-populating of the name and the address, the voter-specific information can be provided?
There is a practice now engaged in by many groups, including
Both sides.
political parties, that deal with the absentee ballot application, not the ballot itself.
Okay.
The ballot is always in control of the election official and the voter. And that is that they, to get their supporters to participate in the process, they will send a pre-filled out application. And it has caused a lot of headaches in the sense that usually the mistake isn't with the voter information, it's with where to send the application on that. But I did use that as an example where people involved in the process have taken advantage of technology. Both political parties have extensive lists of people that they think represent their views, and they want to make sure that they participate. In many cases, the practice is, if we get you to vote absentee, we can get you on election day to drive voters to the polls or to observe. There's a whole reason for that type of grassroots organizing. I think that's a much different situation because the voter controls that. They still have to get the absentee application to their clerk. And where I've been concerned and where we were part of these groups is, one, we want to make sure if you're going to tell a voter, this is where you send it, but you give them the right information. In the past, we've seen political parties say, send it to the town of Washington clerk. Mm-hmm. And there are 12 towns in Washington in this state, and it goes to the wrong one. The concern that's come up in the last round of elections, quite frankly, is one that we've raised with our board, and that is the fact that these applications were not returned to the clerk, they were returned to the third party.
Exactly.
I have a legal issue with that. We have to deal with that separately. Because I think the law requires that, again, voter gets their application to the municipal court.
And so you're doing the comparison that the petition is slightly different than the application for the absentee ballot is kind of where you were hanging your hat on, and that the petition then goes out of the control of the voter, so to say, and goes into a process that is similar to the process, not exactly, that the ballot does. So you're saying that those two things you used as more of a parallel to get where you are? I'm trying to understand.
You know, I think I used the example last week in a different way than what you're drawing it here, and that was to point out that people have taken advantage of technology, been involved in politics, and that I see a significant distinction between a voter asking their local elected official for a ballot, and I see a voter engaging in the process of saying, we want this person's name on the ballot, we want this particular referendum on the ballot, we want this person to stand for recall.
Okay, and then, so to finish around that, and then I have one other issue that I want to make sure I have clarity on. Right, so to finish around that, the person who signs will also have to write their name and their address. That's what I'm understanding.
That's right.
Okay. And then the other issue that you created a different position on was like the pre-populating made it for easier access. The other issue that made for, one would argue, an easier accessible process to voting for students was that the stickers would be used. Oh, you didn't get to explain them yet. Oh, okay. All right, well then I'll wait for the second issue since we've only dealt with the first. Thank you.
Thank you, Senator Taylor, and I do appreciate your comments about the give and take that has occurred here, and I really do believe that as a committee, you know, we came, we learned, we heard, we listened, we discussed, and that really is what our role is, so I'm happy to see that we are moving forward in that direction. And the only other thing I just wanted to clarify about the memo, we all received it this morning at 9 o'clock in our offices. It was hand-delivered, so it was the first we got of it as well.
And Madam Chair, I'll say that I appreciate that, and I still want to reprimand him and say that that's not good.
Well, all right, thank you. Senator Grothman, you're next.
Now we have Senator Visser.
Thank you. Well, I got to reiterate what's already been said on one point. This memo, I didn't get until I was here. And had I gotten the memo yesterday, I probably would have not turned out a fairly wild, a fairly active press release on what I thought this committee was going to do. And I would appreciate, if we're going to change directions, that we know about it before the meeting. So I do think that getting the memo here at this time is a little on the late side. I'd appreciate it getting it sooner. I don't want to commend you, though. I think that withdrawing a request for rules is the way to go, and I hope the committee will accept that, because no way could we make it more partisan than by going the rule route, because as we all know, the legislature passed a bill earlier this year that any rules have to sit on the governor's desk until he's satisfied with them, and then they can be further considered. So if we had gone the rule route, as we were talking about in the last meeting, the whole process would have ended up on the governor's desk, and then it would have been strictly 100% partisan, because no matter what the governor did, it was up to him and not the legislature or anyone else. And so I want to commend the committee and Mr. Kennedy for deciding that the rule route is not to go, because that would definitely make this a partisan situation to 100%. Are we talking about the sticker program now? Because I'm concerned about student voting. I'd like to talk about that.
Mr. Kennedy will address that after we finish questions.
Okay, but when you address it, could you address the comment you make about saying that the university is willing to do this? I'd like to know how many universities say that and how they're going to handle the cost of this. But when you make the comment on it. Thank you. I'll hold my remarks until later.
Representative Hebel?
Thank you, Mr. Chair. And Kevin, obviously, the most important role GAB plays is a watchdog for our elections. And it's extremely important that that watchdog remains independent. I do have a question of Ledge Counsel, and that is with regards to the definition of rules under 227.01 of the statutes dealing with the definition of rule. The reason I bring this up is because under that definition of rule, this body, JCRAR, has no place to be dealing with under exception Q. It talks about is a form, the content or substantive requirements of which are prescribed by a rule or a statute. I believe that part of the statute takes our action with regards to the rules that are promulgated by GAB out of our auspices. And so I'm not asking you for an answer today, but I think it's extremely important that we use our statutes and make sure that we look at definitions and apply them to situations such as this. Because frankly, I don't believe we have any authority with regards to that definition. And of course, this deals with the pre-filled forms. But I believe that's out of the parameters that we're allowed to act under the statute. Thank you.
If I could respond to that, our motion really did not deal with the form, it dealt with how the form was filled out. And that certainly is a deviation and a change. And that's why we moved forward and we felt that was within our jurisdiction to do so.
With all due respect, I would just ask Ledge Counsel, since their function is to provide us with legal advice, even though we do have several lawyers on this body, I would prefer to have an independent voice verify that, because I disagree respectfully with the chairman.
And I think that Representative Hebel, and we will let Ledge Counsel speak on this, but he spoke on this at the last hearing as well. Scott, if you'd like to say a few words.
Yeah, the exemption from the definition of rule that Representative Hebel refers to exempts forms, the content or substantive requirements of which are prescribed by a rule or statute. My understanding of that is that there are, the question I suppose that's before the committee is whether these issues are prescribed by rule or statute already, or whether they are new issues that would render that reference to forms inapplicable. And to that extent, I would read it in the sense that if a form, if there's a statute or rule directing the agency to complete a form and the contents of that form are spelled out completely by that rule or statute, that's when this form exemption would kick in. To the extent that it's debatable whether the form or form is providing new information, providing things that aren't prescribed by rule or statute, those are the situations when I'm not sure this exemption would apply.
So I would entertain the discussion or debate about that at a future date, because I do believe the statute is clear that these type of rules do not apply, certainly with the action that we're dealing with the AD. Thank you.
Madam Chair, or Mr. Chair?
Senator Taylor?
Thank you. On the issue that Ledge Counsel just spoke to, I would like that in writing, and I would like supported case law related to that, because in the way that Representative Hebel has brought the issue to point, I really believe that there needs to be full clarity on how you got there, and although I just heard your words, I did not see how you jumped from what the statute said to your reasoning, and so you lost me in that, and so I'd like to see that in a legal kind of brief almost kind of way, to have some clarity on how you get there.
I'll put together what I can. I'm not sure that the specific paragraph of that definition of rule has been litigated. So, but
right, it may not have been litigated, and so when I say in the sense of a legal brief, I guess part of what I'm saying is for you to reason it out, and to because if we're going to have the discussion, which I think is an important discussion that we probably should have, because I think that Representative Hebel has brought up a piece that's probably, you know, why there's more than one lawyer in his family. Real thoughtful over there. I think that it's an important piece, and I know that we've lost some of the, and no disrespect to young lawyers, I'm one of those too, but we've lost some of the wisdom that has existed in ledge counsel and been around and really are able to give us some stuff. And I'm really excited to have wisdom on my left to be able to talk about what has happened in this Capitol and on rules committees and period. So this is something that I think, as a lawyer, I'm challenged with following where you are, and I can only imagine that it would be helpful to other individuals who, you know, may or may not be saying that it would be helpful to them at this moment.
I'll look into it.
Thank you.
I haven't been a lawyer very long. I definitely would qualify as an older lawyer, though. But I guess, and we certainly, I know Scott will produce a fine memo for us on this. Just for the information of the committee and anyone here today, our reasoning and moving forward on this as a committee, and we're aware of that section Q that says forms are exempt from rules, is that if you were to put a broad interpretation on that, basically an agency could come up with any form that would be completely counter to existing law, and we would say we can't touch it because it's a form. I guess our thinking, again, as committee co-chairs, was that this particular form actually would result in a change in policy. So that's our reasoning, but we can certainly look forward to hearing from ledge counsel on that. Any other questions from the committee before Mr. Kennedy moves on to the issue of stickers on ID cards?
Representative Hebel, did you have any other questions? I didn't know if you had heard that.
We're moving on to the
yes,
issue of
yes.
stickers unless there are further questions from the committee on this issue.
Yeah. What I'd ask the co-chairs is that because of the short notice that we received on the information provided by GAB and the fact that you have a public hearing, I believe, on November 4th, is that what your testimony was?
Our agency's next meeting is November 9th.
November 9th. What I'd do is make a motion that this body not take any action with regards to the rulemaking process until after the public has had a chance to appear at their meeting. I think if we're going to include the public, which I think is absolutely necessary, we should give them the opportunity to participate prior to us making a decision on these rules or any other rules. It seems to me that if we're going to, what's the purpose of the public hearing if in fact we're making decisions that will then make those public hearings irrelevant? So I would ask the chairs if we could delay any further action on these issues until after the public hearing held by GAB. Then they will have the input that they need to really make the absolute best possible rules. And that's what all of us are after here in Wisconsin. We want the best.
Actually, Representative Hebel, we are thinking along those lines
Okay.
based on what Mr. Kennedy says this morning and based on his memo. So
Wonderful.
we're thinking along those lines, but we'd like to hear the remainder of what he has to say
Oh,
today.
wonderful.
So,
Thank you very much. I appreciate your consideration of that.
Mr. Kennedy, if you'd like to
Mr. Chair,
proceed.
before Mr. Kennedy speaks, I just want to just go, this is a good moment. We're thinking on the same lines. Okay.
Mr. Kennedy, you may proceed on the issue of stickers on student ID cards. Thank you.
Certainly, thank you, Mr. Chair. The second issue that the committee raised in our discussion last time was the fact that the staff, much of the board, said we have concern about the cost of getting student IDs to be in compliance. We've had a lot of dialogue back and forth with various representatives of colleges and universities. And the real issue was not so much the ability to use a student ID, but the ability to have a student ID conform with the statutory requirements. And universities were expressing concerns, and quite frankly, and colleges as well. And so they were looking at how can we meet what the law requires so that our student IDs can be used. And one of the suggestions had been the use of stickers, given the timing. And we talked about the fact that this meeting, and I mentioned here, that student IDs have evolved significantly since the 70s when I was in college and law school, in terms of the picture is better, which is a good thing for some people, maybe not for me. But those IDs are used as more than just a form of identification to get student tickets to sporting events. They actually access a wide variety of services. That way they are set up in a way that they can interface with a lot of technological support systems on those campuses, such as opening door rooms, accessing instructional materials at libraries, tapping into financial drawdowns for meal plans or buying text books, things like that. And so is the cost of redoing that, and also the fact that universities are used to the fact that students are there for longer than the 2-year statutory period. So they will issue an ID card that they can track its, whether it's students in electronically, but they're going to put a facial expiration that's usually 4 or 5 years on that, which is contrary to the statute. So in the ongoing discussions with them, one suggestion was, well, what if we were to use stickers on this? And the concerns that came up that we identified as part of it, and I think we heard this from the committee, had to do with the integrity of the stickers. Universities, after thinking it through, were thinking, this is going to get in the way of the use of our ID cards. What about if we were to take a different approach and we have different types of identification provided at different times? They have to often provide identification in response to other governmental inquiries. They're looking at developing an ID card that would be provided to voters, to students who couldn't get access to another type of identification. That it would be in response to a student request. So in other words, they would have a second ID that conformed to the statute, so if you limited its time period, it would have the issuance date, the expiration date, the signature, and could be linked up with proof of current enrollment as well on that, so that it was tied very specifically to that use. And the feedback we got after the stickers was, in our discussions with the university system, that there were really only 2 of the campuses that were giving some thought to that, and one of them was also weighing very heavily, well, what about a second ID? And the focus of the committee's concerns were, if you use stickers, we want to make sure that there's some integrity to them, that they can't be duplicated, that they're not going to fall off, that they're not going to interfere, and that's the kind of rulemaking you want. And what I think we've learned is that, practically speaking, there's no reason to use stickers to conform IDs if there's another way to do this. And for us to get involved in the rulemaking process when for something that would not happen seemed like a gross misallocation of everybody's resources here. I think that, as I said, the goal here was, how do colleges and universities conform their identification to law? I think by looking at the concerns about a temporary fix, we can say that's not a good fix, and they're already, from an administrative standpoint, moving from that anyway. And the only wrinkle I see with that is that we do see people who, entities that have identification cards that otherwise conform, but they ask the student to sign on the outside of that, either on a strip like on a credit card or some other, or it's the signature. And it struck me, and I mentioned this, that the signature is one piece that we can always compare with the signature that's going to be on the voter list. We can compare if there's an issue somehow that being misused. And so my suggestion was, rather than direct us to engage in rulemaking for a process that probably wouldn't be in place, that we go back to the board and also between now and our November 9th meeting, talking more with the various colleges and institutions, say you need to not rely on this approach and get some assurances that they're not. We don't even have to develop a policy in that process. We can say there's no need to use stickers because you're changing your IDs in this process. And we know that I think that's generally the preferred way that they would want to go anyway on this, because they recognize the problem with that. Lobbyists, as I understand, talking with various legislators involved in the photo ID bill, was for the EW system said we're not enamored with stickers for those very practical reasons that we just talked about. So my recommendation is that it's not even a road that universities and colleges are heading down, so why develop rules in this area? Instead, we say, well, we don't need to use it because we've got other approaches to this, and so it wouldn't be an option for them.
Thank you, Mr. Kennedy. I guess my only concern with a sticker for a signature is that when you clarify what your motion would be on that there'd be at least some safeguard that this truly was a signature script produced by the college or university. I think your original motion said that there would be some indication that it was produced by the college or university, but something a little bit more safe that it actually was. That would be my only concern with it.
And maybe not even get to that point. It may be, in talking with the various institutions of higher learning, they wouldn't be looking at that.
Senator Taylor? Senator Visser.
Yeah, I'm very concerned about student voting, and I want to be darn sure that there's nothing to stop them from participating. I got 40,000 students in my district, and I want to be sure they can vote. Now, my question to you is this. You talk about a second ID card, but that's not going to work, because if you have a student ID card now that lasts for 5 years, and that's no good, then everyone's going to have a second card that says only 2 years, or whatever the length of time is concerned. So that means every student's going to have 2 cards. If the first card talks about a 5-year term, and the second card is limited to, what is it, 2 years or 1 year?
2 years.
2 years. So if you do that, then if you're talking about a second card that is valid, and they have to have that first card that's good for 5 years, then they have 2 cards, one for 5 years and one for 2 years. And then they got to get the 2-year card renewed every 2 years because it can only last for 2 years. My question is this: you say in your memo that you have been informed that you say that you now are being informed that most, meaning colleges, would prefer developing a second card. My question is, informed by whom? Did this campus inform you? Did the 13 campuses inform you? Did one person inform you? Who's informed you? And I mean, there's a cost involved here, and I still understand that this campus is concerned about the cost of producing all these cards. So I want to know who informed you that this was a good idea, and whether my campus, for instance, is involved in that information.
Our discussions have gone primarily through the UW system's legal counsel office. And they have been talking with the various campuses and how they would approach that, trying to come up with a uniform approach to this. As I indicated last week, sometimes it wasn't clear that the legal offices were talking with the lobbyists, but that's part of the way this thing works, is there's always an ongoing dialogue on this process. I think, just to clarify, what the universities are recognizing is that in many cases, students, and we can use UW-Madison as an example, are not going to need to use their student ID card to vote. They will have access to their Wisconsin driver's license. But we also recognize that there are people who attend the UW-Madison, as an example, who either don't have a driver's license in their Wisconsin residence, or they're eligible to vote in Wisconsin, but they have moved here from another state. The residency for paying tuition is different than their residency for voting. And the recognition, what I said at the beginning, was driving the concerns of the universities and colleges are they have had an identification system in place to serve their educational needs and their administrative needs for education. And it's not and to adjust that to the very narrow parameters that are in the definition of a student ID would require them to make some cost adjustments. And they were able to calculate that for those students who would need the student ID because they didn't have access to a Wisconsin-issued identification card or a Wisconsin driver's license, or they didn't have their passport or a military identification card to use, that they would be able to obtain this. In other words, 40,000 people on the University of Wisconsin-Madison are probably not going to carry 2 IDs, 2 student IDs. They may carry 2 IDs, one a Wisconsin driver's license or identification card and a UW ID. But in order to facilitate voting, they would be going directly to the student services, getting an ID that is tailored to the statutory requirements. And the sense was that would be much more cost effective than taking the 40,000 IDs, reissuing them, because one of the costs is they have a 5-year ID. And if they have to scale it down to 2 and reproduce it, that's a significant cost. But if they're looking at a much smaller subset of individuals, in other words, we still provide the opportunity to vote. We still provide them within the framework that the legislature has agreed upon. But it's uniquely tailored for the voting purposes, and it doesn't get in the way with the rest of the administration. That's the approach that the administrators are finding is a much more effective one. Because again, I think they've recognized that, again, I'll use Madison with its 40,000 plus students.